Take that thing off. Where it says got it.
Oh. I don't know why this started popping up on me.
Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2, Jefferson County, Texas. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been summoned to come here to court for what is called the arraignment. And what the arraignment is an opportunity for the court to tell you what you've been charged with, what your rights are, and what options you have regarding your case. Now, the case that you have is a misdemeanor case. We only handle misdemeanor cases in county court at law. And the felony cases are handled in the district court. So criminal cases are divided into misdemeanor cases and felony cases. Your felony cases are known as your more serious type offenses, and your misdemeanor cases are referred to as petty offenses. Now, it does not mean that your offense is not serious. Your felony cases, the basic difference is that with the range of punishment that they have, an individual can be sent to the state penitentiary for punishment. For example, if you have what is called a capital murder case, and if you're found guilty, you could be given life or death. If you have a first-degree felony, the range of punishment is a minimum 5 years in the state penitentiary to a maximum of 99 years to life. If you have a second-degree felony, the range of punishment minimum 2 years in the state penitentiary to a maximum of 20 years. If you have a third-degree felony, minimum 2 years, maximum 10 years. And if you have a state jail felony, the range of punishment is 6 months in the state jail to a maximum of 2 years. And in those felony cases, fines can be assessed up to $10,000. Now, for your misdemeanor cases, the misdemeanors are divided into Class A, Class B, and Class C misdemeanors. In this cohort, we normally handle Class A and Class B misdemeanors. However, a Class C misdemeanor, if it's appealed up to this court, then we will also handle the Class C misdemeanor. Now, the Class C misdemeanors are normally handled, well, they ain't say normally, but they are handled in the JP court, the Justice Court, or the municipal court, which is called city court. And it's normally, just to give you an example of what a Class C misdemeanor is, for a Class C misdemeanor, you can only get a fine. You cannot get any jail time. So for example, a speeding ticket, that's a Class C misdemeanor. Now, the Class A and Class B misdemeanors, Class A is the highest misdemeanor and Class B misdemeanors is right below that. For a Class A misdemeanor, your range of punishment is anywhere from 0 days in the county jail up to 1 year, which is 365 days in the county jail, or anywhere in between. A fine from $0 to $4,000 or anywhere in between, or you could be given both such fine and confinement. For a Class B misdemeanor, the range of punishment is 0 days in the county jail up to 180 days, which is 6 months in the county jail, anywhere in between. You can be given a fine from $0 up to $2,000 or anywhere in between, or you could be given both such fine and confinement. Now, you may qualify for probation. There are two types of probation. One type of probation is called unadjudicated probation. We commonly refer to it as deferred adjudicated probation. The other type of probation is referred to as adjudicated probation, and we normally refer to that as regular probation. The difference between the two is with the unadjudicated probation, it does not result in a conviction in your record, whereas the regular probation does result in a conviction in your record. Now, if you get unadjudicated probation, and if you successfully complete it, the case will be dismissed, and you may qualify for what is called a non-disclosure. A non-disclosure means we cannot disclose to the public that you are on deferred adjudicated probation for that offense. However, if you violate your deferred adjudicated probation, the state can file a motion to revoke your probation. And if your probation is revoked, and you may get a conviction. If you get a conviction, obviously, the case is not going to be dismissed and you cannot get a non-disclosure. Now, with the regular probation, as I stated earlier, it does result in a conviction on your record. However, there is something that is called judicial clemency. Judicial clemency means that the court or the judge can set aside your conviction. In essence, you will no longer have a conviction. Now, the way it works, first of all, you have to successfully complete the regular probation. The court, you cannot have any more time left on the probation. All your time has to expire. And then the court has to discharge you, which means to let you off of that probation. If those things happen, the court can allow you to come back in the court to withdraw, which means to take back your plea of guilty or no contest to that charge. And any complaint, affidavit, or information that has been filed against you will be dismissed. And you will no longer have a conviction against you. You can truthfully say that you was not convicted of this case. However, if you get a subsequent conviction, meaning that if you get another conviction later on, then the case can be brought back up and used against you. And if you try to get a license with CPS, they can deny giving you a license, or if you already have a license, they can revoke or suspend that license. As a defendant in a criminal case, you have three options. Number one, you may hire an attorney. Number two, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. And number three, you may represent yourself. If you want an attorney to represent you and have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. You will be given a form like I just read, and at the bottom of that form, you'll have to make a choice. And it says defendant's choice, mark initials next to only one choice. If your choice is you want to reset this case to hire your own attorney, then you'll put your initials on the first line to the left. If you've already hired an attorney, then you will put your initials on the second line to the left and the name of the attorney on the line to the right. If you would like to apply for court-appointed counsel, then you will put your initials on the third line to the left, or if you've already been appointed a court-appointed counsel, a court-appointed attorney in your case, then you will put your initials on the fourth line to the left and the name of the attorney on the line to the right. Now, if you want to waive your right to an attorney and represent yourself, you'll put your initials on the fifth line to the left. Now, once you finish signing, or excuse me, once you finish initialing one of the 5 lines, then you will sign the document where it says defendant, and you will date it today's date, August 31st of 2021. Now, you also have other rights. You have a right to have a trial by jury. And what a trial by jury is, 6 citizens from Jefferson County will be selected to sit in your case, and they will decide after listening to all the evidence whether or not you're guilty or innocent. You also have a right to waive or give up your right to have a trial by jury. Waiving means that you would like to give up your right to have a trial. And so you want to give up your right. And so you'll have that option too. Now, if you desire to waive or give up your right to have a trial by jury, then your case just will come before the judge. And so it will either be through a jury, well, it will either be through a trial, or it would be through what we call a plea. And what a plea is, if a person work out an agreement with the state to settle their case, we call that a plea bargain agreement. Now, if you have waived your right to have a trial by jury and you would like your case to come before the court, your case will come before the court either by what we call a bench trial, a trial before the judge only, or a plea, and the plea could be agreed or unagreed. An agreed plea bargain is y'all reached an agreement. An unagreed plea bargain is you and the state have not reached an agreement and you want the judge to assess the punishment. Now, you also have a right to have witnesses to come to court and testify in your case. They can testify for you or against you. You can ask them questions. We call that either direct examination or cross-examination. Now, you can waive or give up your right to have witnesses to testify in your case as well. Now, by doing so, you will not be calling any witnesses to testify in your case. However, the state will be calling witnesses to testify in the case that they have filed against you. You also have a right against self-incrimination. The right against self-incrimination means that you have a right not to say anything in your case. It's commonly referred to as you have a Fifth Amendment right against self-incrimination. You hear people saying, I take the fifth, which means I don't want to testify in my case. And so that's a right that you have. Now, if you desire to waive that right and you want to testify, then you'll be giving up the right against self-incrimination and you will be testifying on your behalf in your case. You also have a right to have discovery. What that means is you have a right to see the evidence that the state has against you. So you have a right to see the videotapes, if it's a videotape, the witness statements, documents, or whatever the state has in the case against you. You have a right to have, if you're representing yourself, you have a right to have access to it. And if your attorney if you have an attorney represent you, the attorneys will be given access to it as well, and he'll be given copies of videotapes, etc. Now, you also have a right to waive or give up your right to have discovery, which means that if you do not want to see the evidence, you have a right to waive or give up your right to have access to the evidence as well. Now, each and every one of you have been arrested on your case, and you are out of jail now because you have bonded out. Every day that you have spent in jail, you can use, that can be credited towards your punishment. For example, if the state is offering you 5 days in jail, you've already served 5 days in jail, you will not have to serve any more time in jail because you'll be given credit for time served in jail. Now, if you have less time than they're offering, for example, if they're offering 6 days in jail, you have 5, that means you would have to do 1 day in jail on your sentence. Now, every day that you spent in jail also is credited as $100 per day toward your fine and court costs. So if the state is offering a fine and court costs of $500 and you spent 5 days in jail, that's $500. You will not have to pay the $500 because the $500 will be taxed and retired because you've already served 5 days in jail, and that's $500. Now, if they're offering a fine and court cost of say $600, that means you would have to pay, if you got 5 days in jail, that means you're gonna have to pay $100. Now, if you can't pay the $100 on the day, or if you can't pay the fine on the day of your plea, then what will happen is we can give you time to pay it off, or we can put you on what is called scheduled payments, which is a payment plan. Now, let's say you can't pay it off, even if they put you on a payment plan. Then if that's the case, then we can convert your fine and court costs to community service, which means you can work it off. Now, every hour of community service that you do, $12.50 will go toward your fine and court costs. So if you work 8 hours a day, one day, that's $100. So if you had to pay $100, you would just work an 8-hour day and that would satisfy the fine and court costs. All right. Now, let's say, yes. Yes. It's outside the door. Yes. All right. Now, let's say you cannot, okay, let's say, okay, with the community service, if you cannot do the community service, there are other things that can be done as well. And that's pursuant to what we call Section 42.15 of the Code of Criminal Procedure. Now, Jefferson County District Attorney's Office has a program that is called Pretrial Diversion. And what pretrial diversion is for people who are first-time offenders. They haven't been in trouble before. They'll put them in the program and they'll dismiss the case, and then you could get it expunged, which means erased, deleted, or wiped off from your criminal record. Now, the way it works with the program, you would have to first of all, it cannot be an offense involving unlawfully carrying a weapon, and it cannot be an offense involving resisting arrest. And you cannot have like I said, a criminal history. And you would have to get you will be required to have a lawyer to assist you in getting into the program. And if you get into the program, case dismissed, and then you complete the program, you can get it expunged from your record. All right. And you can talk to your lawyer or the DA about how that program actually works. Now, let me just repeat that again. Now, with the pretrial diversion program, it's for first-time offenders. If you haven't been in trouble before, you complete the program, the case is dismissed, and you can get it erased or deleted or wiped off from your record. You have to have a lawyer to help assist you in getting in the program. You cannot you cannot have an offense, the one that's resisting arrest or unlawfully carrying a weapon. And you have to, I said earlier, you have to have a lawyer to assist you to get into the program. You cannot have a criminal history. All right. Now, if you are a veteran of any one of the branches of the United States military, doesn't matter, it doesn't make a difference what branch it is. Jefferson County District Attorney's Office has another program that is called Veterans Court, and it's for veterans. And the way you get in, you just have to be a veteran. You get in the program, it's like pretrial diversion. You complete the program, they dismiss the case, you can get it erased, deleted, or wiped off from your record. It can be expunged, okay? That's for veterans. It's a pretrial diversion program. Now, this court, County Court at Law number 2, we have a program that I call the CSI program. It stands for Community Safety Initiative. It's a program that started in March of 2017. Within the first 100 days that I was after being sitting on the bench, after I got into office, within the first 100 days, I started a program called the CSI program. And the way the program works is we have partnerships with agencies in our community. We have a partnership with Spindletop Center, used to be called Spindletop MHMR. They have a program, it's a mental health program that they have. They can do interviews, private interviews Uh, They can develop assessments and they can develop a treatment plan for individuals to address their mental health needs. Uh, Also, Spindletop that is, have a program that is called ATAR, ATAR, stands for Addiction Treatment and Recovery. It's a drug treatment and an alcohol treatment and recovery program. They can do interviews, they can do, uh, they can also develop a treatment plan for individuals, either outpatient or inpatient as well. They can also do a screening. The other thing is we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. What that is, it's a program, it's a job training program and a job placement program in the hotel industry or the shipping industry or the chemical industry. Once they assist you with the training, once they train you, they will assist you at getting a job in the area that you're trained in. And if you need any information on that, we have information as well. What I forgot to mention is that with Spindletop, we have some folks in the courtroom today. They'll come around and talk to you to see if they can address any mental health needs that you have. And they will also be willing to do a private interview in the back. Now, if you have not graduated from high school and you would like to get your GED, Lamar has, the CSI program has a GED program as well, where you can get your GED as well. Now, all of these programs that I just mentioned are free, doesn't cost you anything. Only thing you have to do is have a desire to be in the program. And these programs are designed to address the issue of what we call recidivism, where people commit crimes over and over. And so to stop that or to reduce recidivism, I have the CSI program. And it's designed to make Jefferson County a safer place for all of us to work, go to school, have children to go to school, raise families, go to church. In essence, it's designed to make Jefferson County a safer place. And this program, as I tell people all the time, that in the County Court at Law number 2, we don't just have court as usual, we have unusual court. Because, and the reason why I say that is not because we're different, but it's because we're trying to make a difference in the lives of the individuals that comes before this bench, and we're trying to make a difference in Jefferson County by making Jefferson County a safer place. This program also is designed to produce productive people, and by producing productive people, for the most part do not commit crimes because they have too much to lose, okay? And so if I tell people this all the time as well, with this program, we don't just give time, we take our time. And we do not just arrest the problem, we address the problem. And we believe that if we address the problem, then we can make Jefferson County a safer place, we can produce productive people. And so that's what it's all about. Now, we have some individuals in court today from Spindletop. We have Deputy Hinton, we have Jess. One of them is gonna come and tell you something about their program. And at this time, I'll turn it over to Jess.
Hi, my name is Jess. I'm a qualified mental health professional in Spindletop. I'm here with Steve Hinton, a deputy with Jefferson County Sheriff's Department. The judges graciously allowed us into the court today to talk to y'all. We found that most people that come into court have mental health or substance use issues, and we like to address those problems here today if we can. We can talk to you privately and confidentially. Everything we talk about will be HIPAA regulated. We'll also give you a pamphlet that has more information about what we do, as well as a crisis hotline number, as well as our number if you need to get in contact with us. And maybe, this doesn't apply to you, maybe it applies to someone you know, you can use that information to pass along to them as well. Any questions for me? Okay, well, just listen to the ladies over here, they'll tell you what to do, and we'll be around to talk to you guys.
Okay, so, ladies and gentlemen, just, we have some paperwork to pass out to you. I mentioned earlier that we had this form that I read to you. We're gonna pass it out to you on a clipboard. You can read it. Now, if you need any assistance, we have, individuals on our staff that can assist you with that, okay? So just bear with us a few minutes. Now, if you need to use the restroom or anything, it's right outside the door, but do not leave the courthouse, because if you leave the courthouse before, we take care of your case, unfortunately, a warrant will be issued for your arrest. Okay, and so just bear with us for a few minutes, okay? All right.